Deliberate Speed, Reflections on the First Half Century of Brown versus Board of Education.
Charles Ogletree Jr., where does the title All Deliberate Speed come from?
It actually comes from the second case in Brown versus Board of Education. The first case that we all know about was decided on May 17th, 1954. But after the Supreme Court said we have to end segregation, it had a second decision to decide how to implement that. And on May 31st, 1955, it said, we're going to end segregation, but we're going to do so with all deliberate speed. And that became my mantra, the idea that Brown was a colossal, very important decision. But the second Brown decision to implement it took away much of the moral courage and the force of the first decision.
Who was Brown and who was the Board of Education?
Well, it was interesting that Oliver Brown was the father of Linda Brown, a young African-American girl from Topeka, Kansas. She was concerned that she had to walk a long distance from her home to go to school because she was black. And the NAACP, with the great leadership of Charles Hamilton Houston, Harvard-educated lawyer, and Thurgood Marshall, and others, looked around the country and they found 5 places. The case is called Brown versus Board of Education. It's Oliver Brown against the Topeka Board of Education, but it's 5 cases. The NAACP brought cases in Virginia, but in Delaware, in South Carolina, but also in Topeka, Kansas, and in the District of Columbia. So it was a concerted effort to say, Supreme Court, this time you cannot duck the question of separate but equal education. We're showing you this is a national phenomenon. And Brown versus Board of Education is the name of a case that's actually 5 cases.
Would you be sitting here without this case?
Not at all.
Why?
I might be cleaning up here or doing something else, but I wouldn't be sitting here as a professor at Harvard Law School. My entire life is influenced by this case. When the Supreme Court integrated public education, it created opportunities for me from my little hometown in Merced, California. I'm sure it had a big impact on my ability to go to Stanford University, even though I did end up graduating with honors. It had a absolutely significant impact on my going to Harvard Law School and being a tenured faculty member there now. I was not the first qualified or the most capable. It's just that others had made sacrifices, and I stand on those broad shoulders. I would not be here. I could not be here, but for the sacrifices of great teachers, and the great lawyers who made these cases a reality.
You have this double-sized picture in the middle of your book. Who are these folks, and would they be where they are today without Brown versus Board?
You know, some of them might say that they would, because those are all Harvard Law School graduates.
Are they all African-American?
All African-Americans graduated from Harvard Law School from the 1960s till the year 2000. And we held for the first time ever in Harvard's history a gathering of all of its African-American law graduates. It was a celebration. That's what it was called, a celebration of Harvard's Black alumni. And the goal was to say, let's just take a look at what has happened. And it tells you that Harvard Law School has had a profound impact on the ability of African Americans to have upward mobility in many places. And it goes beyond that. This picture exemplifies other greats who were there. Ken Chenault, who's the president of American Express, he is a Harvard Law School graduate. Frank Raines, the president, Fannie Mae, another Harvard Law School graduate. Loretta Argret, who was the head of the tax division in the Clinton administration, a Harvard Law School graduate. These African Americans have had incredible mobility because of those opportunities. 7 of us are on the faculty now. I've taught students who are teachers now, partners in law firms, leaders in business and industry. So Brown opened up doors that weren't imaginable. That picture could not have been taken 10 years ago or 20 years ago or 30 years ago. But now it's a celebration. We've arrived, and it's no time to look back or to go back.
Put on still store, we call them, the names of the members of the Supreme Court back then, and they're on the screen here in just a second. The first one on that list is Hugo Black, and it shows the state he was from originally, the years that he served, and he was there 34, off to the right. Stanley Reed, Felix Frankfurter, William O. Douglas, Robert Jackson, who William Rink was clerk for.
That's exactly right.
Harold Burton of Ohio, Tom Clark of Texas, Ramsey Clark, his son, became Attorney General.
Right.
Sherman Minton from Indiana, and Chief Justice Earl Warren of California. Anything about that particular court that's important to know?
Well, what's about that court that's important is an eclectic court. Hugo Black was justice who was appointed. People were concerned about his former ties to the Ku Klux Klan. He disavowed those when he joined the court. He was one who was very concerned about rights during the Warren Court era when he was there. But what's missing actually is Fred Vinson. That's the sort of untold story. The court that was going to decide Brown was a radically different court in disposition. In 1953, the judges were split entirely and ideologically in whether or not they would end Plessy versus Ferguson's 1896 philosophy or doctrine of separate but equal. And it's reported, based on memoranda held by the justices then, that Chief Justice Fred Vinson from Kentucky was one of the 5 who would uphold Plessy and not integrate the schools. Amazingly, on September 8th, 1953, after the case had been argued and they were waiting for a decision, Fred Vinson died. And it was clear that Felix Frankfurter, Harvard Law School professor and a member of the court, who was very bright, did not like Vinson. It's reported that he said at the time of Vinson's death, his chief justice and a colleague, he said, "This is the first indication that I've ever had that there is a God." That's a pretty strong statement for one justice about another. And Vinson's death allowed Earl Warren to join the court. Warren had been the governor of California. He was the attorney general during the Korematsu, the internment of Japanese Americans during the Second World War. But Eisenhower thought that he would be a person who could bring consensus, and that is exactly what he did. And it's hard to imagine another chief justice who's had so much success in bringing these disparate points of view together. And what Warren did was to talk to the justices, try to alleviate differences, and to say, we need to speak with one voice. And up until May 17th, 1954, there was not a single voice. There were many voices. Some wanted to write dissents, some wanted to write concurring opinions. But Chief Justice Earl Warren took his time, the politician that he was, to go justice by justice, to understand their fears, and to get them to come with unanimous decision. It made all the difference in the world that in 1954, after 58 years of Jim Crow segregation, the Supreme Court said with one voice, separate but equal is inherently unequal.
There were 2 decisions, as you say, Brown 1 and Brown 2. Go over, what did Brown 1 do again, May 17th, 1954?
What Brown 1 did to say, right now we are proclaiming for once and forever that segregation as we knew it, that was operative and legal, is ended today. The question was, and how do we implement this? What do we tell all the various states? What do we tell all the schools? What do we tell the federal courts? What do we tell them? And say, we want additional arguments. Justice Frankfurter was particularly concerned about, how do we do this? There's going to be Southern resistance. There's going to be reactions. We don't know how we can enforce this without thinking about it. Let's hear arguments in terms of what's the remedy. The right is to equal education. The remedy is how fast. Thurgood Marshall and the lawyer said it should be forthwith. You've made a bold decision. Now support it by saying end segregation now. The court came back on May 31st, a year later, and said, we are going with these orders to end segregation, and it said with all deliberate speed. The lawyers didn't even quite realize what had happened when that originally happened, and there was a secretary who went and looked up the word deliberate and learned that the word deliberate meant slow. And so the Supreme Court was saying, we'll end segregation, but it will be done slowly, and it was slow. Governor Faubus in Arkansas stood in the door, said, black children are not going to come to Central High School. Governor Wallace said, segregation today, segregation tomorrow, segregation forever. At the same time, there was this thing called the Southern Manifesto. Members of all Congress came together and said that we're going to fight this push for integration by any means necessary. And at the same time, even Dwight D. Eisenhower, who had appointed Chief Justice Warren, was disappointing by saying that all these Southern whites want is for their sweet little Southern girls to not be in classroom with some big overgrown Negroes. And he said you can't change people's minds or hearts through law. If the chief executive of the country is not committed to this decision, you can imagine how easy it was for others to resist it. To his credit, ultimately in 1958, he was prepared to call in the airborne to ensure that Central High was integrated. So Eisenhower ultimately decided it would be enforced. but he was ambivalent about whether or not the South, in particular, was ready for integration.
I want to show the court one more time for folks that didn't get a chance to see the entire court. Anybody on this list, and we'll show Hugo Black here at the top, that surprises you that it was a 9-0. Was it both Brown 1 and Brown 2 9-0?
Right, both were unanimous decisions. There were a lot of surprises. Justice Douglas seemed very clear that he thought that Frankfurter was ambivalent. He thought he had a few of the votes, but some of the justices just weren't ready. When you talk about like Justice Burton, whether or not he was really ready for a unanimous decision, and there were constant arguments going back and forth. The same was said about Justice Reed, and so there were debates about who would finally support the decision. But Earl Warren has to be given credit for being the ultimate and consummate politician to take 9 men and work this amazingly well. 2 of my mentors and colleagues at Harvard Law School clerked for Frankfurter that year. One, Frank Sander, is still on the Harvard Law School faculty. The other, Jim Bornberg, our former dean, recently died, but he was also on the faculty. And they talked about the court keeping this entire case almost secret. Law clerks didn't work on it. They weren't involved in it. The court didn't want the word to slip out. They thought this decision was very controversial and highly volatile, and they did not really share it with their law clerks until just before it was decided. In fact, Frank Sanders says Frankfurter told him, "Oh, you might want to come into the courtroom today on May 17th," but didn't tell him then what had happened in the ultimate decision. So this was a very significant decision. And the other thing, when you read about it, if you read law cases, if you pull up law cases, you see the legal jargon, the technical jargon. It seems to me that this decision was really written for the public because it's straightforward. It's not complicated. It doesn't have a lot of citations. It's a very short decision, as is the second, Brown 2. And I think the court was trying to make have a message that here we have this issue of segregation. Here we have clear disparity between the schools for blacks and whites. And we have to send a message out that's clear and unambiguous and not tied up in legal jargon. And that's exactly what they did.
And that was 1955 May, the second decision. When's the first thing that happened in this country that made a difference for black kids in either in the South or the North?
Well, it's hard to tell because, let me tell you what didn't happen. There was no wholesale embracing of this decision. In fact, there was resistance. In Arkansas, there's a case called Aaron versus Cooper, decided in 1958, because in Arkansas, there was this constant effort to refuse Governor Faubus and others refused to integrate. And the Supreme Court in 1958 came back and said, we're demanding that you do this right now. And they knew that they had Eisenhower's support. That is, that if we tell them they must do it, Mr. President, you have to make sure you're prepared to send troops. And that's exactly what happened. So even years after the decision, there was still resistance. Ultimately, by the 60s and 70s, you start seeing substantial evidence of integration in the South. One of the reasons this book was written was because one of my points is that we keep thinking the problem of segregation was a Southern problem. It was a national problem. Because as much as we saw every night on TV in the 50s and the 60s, demonstrations in Birmingham and in Selma and in Jackson, Mississippi, and all parts of the South, 21 years after Brown, I'm on my way to law school at Harvard Law School in 1975, and what do we have? We have white resistance to integrated education in the city of Boston. Black children were victims of all sorts of intolerance by whites who felt that blacks were being forced upon them. And I was amazed to see, as a young man going to law school, that there was still resistance in the 1970s to integrated education.
This is a little bit ahead of the story, but tell the story about you and your wife arriving in Boston.
Well, it was amazing because we left California. We were married in the summer of 1975. And we knew something about Boston, but we drove to Boston. We'd rented an apartment found by a friend of ours, Larry Terry, who was a medical student at Harvard Medical School. And when we arrived there that fall, it was quite amazing as we got there. Directions got screwed up, and so I ended up getting off the highway I-93, which is the main thoroughfare in Boston. And I called our landlord, telling him I wasn't quite there, and explained where we were. And he said, "Describe where you are." And I said, "Well, there's Patty's Liquors and there's O'Reilly so-and-so." He said, "Get back in the car. Just get back in the car and find the freeway." What he was telling me is that we had inadvertently driven into South Boston, the very area where there had been racial violence from 1974 and 1975. And we finally got back on the highway, made it into Cambridge, found our little apartment in East Cambridge. And then I realized that this was not just a fairy tale. It wasn't something to read about in the newspaper. I was there in the middle of a crisis in 1975 concerning busing and racial conflict between blacks and whites.
Go back to the courtroom in 1954 and 55. Who were the lawyers or the lawyer that stood up in front of that court and argued the case?
Well, let me go a little bit further back, because the most important lawyer wasn't there. The lawyer who was responsible for the Brown case, the architect of the decision, is Charles Hamilton Houston. He was from Washington, D.C. He went to Amherst College. He's a graduate of Harvard Law School. He was the first African-American to be elected to the Harvard Law Review, which is an honor in terms of academic performance. He also, in addition to being one of the great geniuses, he could not find a job in a law firm because of his race.
Isn't this a portrait here of him in this one picture?
Exactly. Harvard Law School in 1998 had a tribute to Charles Hamilton Houston, and his family came back, and his son, who lives in Baltimore, and his grandson, who's a lawyer in Arizona, and his granddaughter were all part of the celebration. But he couldn't get a job, and he went back to Washington, worked with his father's law firm, and ultimately went to Howard Law School to teach. And he trained Thurgood Marshall, the lawyer who argued the Brown case. He trained Oliver Hill, a 97-year-old lawyer who argued one of the Brown cases. And he trained the next generation of lawyers to fight segregation. There's a video called The Road to Brown, which chronicles Houston's incredible efforts to integrate the South. And many people say that he killed Jim Crow because of all of his efforts. My own view is that Jim Crow might have killed him. He died prematurely. He was just 50 years old when he died in 1950. So before the Brown case was even argued, he died. But every lawyer there, Thurgood Marshall, Robert Carter, Spotswood Robinson, Oliver Hill, Jack Greenberg, a whole host, James Nabrett, George E.C. Hayes, all these lawyers and more had been trained or influenced by Houston. So he didn't argue, but the people who were there were his pupils.
Who was Jim Crow?
Jim Crow was a caricature, and it was a caricature of a sort of shuffling, and sort of an embarrassing character in African American, a white and black face. But Jim Crow was the institution. Indeed, Jim Crow wasn't a person; it was a caricature. But the institution was to show the difference between blacks and whites. And what's amazing is that once we ended slavery in the 1860s, the response was to say blacks are free, but they're not equal. Because we immediately started the process of implementing a Jim Crow system, saying that you are free, but you have to drink at separate water fountains. You have to live in separate communities. You have to work in different places. You don't have certain basic fundamental rights of citizens because we're going to separate you by the race. It's what we call apartheid in South Africa, separation of the races. And it was prevalent in many respects around the country up through the time of the Supreme Court's decision in 1954. And it really didn't end right away. It continued that day.
You have this picture out front in your book, and who's in there?
These are all the lawyers who played a role, not all of them, it's a number of the lawyers who played a prominent role in the Brown cases. It's Thurgood Marshall. He's joined by Spotswood Robinson. You've got Bill Coleman. You've got George Redding. You've got George E.C. Hayes, and a number of the other lawyers who all worked on the case. Jack Greenberg's there as well. A number of the other lawyers who were involved, like William Coleman's not there, Constance Baker Motley's not there. But a lot of the lawyers who were in Washington came to stand on the steps of the Supreme Court after the case was decided.
You say somewhere in your book that your father didn't, when it talks about history, that he wouldn't have known who Thurgood Marshall was, but would have known who Martin Luther King was.
Well, and that was a common, that's the case today. If you go into any public school, black or white, you ask them about Martin Luther King, it's a national holiday, and most people know about that. If you ask them about Thurgood Marshall, most people don't have a clue. Even most law students don't have a clue, because Thurgood Marshall was such a factor in the law, but not publicly known. And indeed, I have a chapter in the book talking about this tension between Marshall and King. And Thurgood Marshall told an amazing story. After he won the case, got in a cab with a black cab driver going to another part of town in Washington. Cab driver said, "Did you hear the good news?" He said, "What's that, young man?" He says, "Well, we won the Supreme Court today." "Oh, what happened?" He says, "Martin Luther King won the Civil Rights Movement." And Thurgood Marshall just had to grin. Here he was having won this case, and Martin Luther King was again getting credit. And I talk about the jealousy, envy, the conflict between the two, because Marshall believed in the law strongly, that the law, you had to work through the court system to make it work. And Dr. King believed that the law was unjust. It was morally reprehensible, and that you had to change the law by force, nonviolent force, by extrajudicial means. And Marshall talked about having to represent King, get him out of trouble, etc., and that there was this tension. And the reality is that they both were important, that it was important to win in court, but these decisions weren't self-effective. That is, that you had to have a mechanism to make them work. And so every time a case was won, there still was a necessity to go into the community and make it work. It said separate but equal ended in 1954, but the same year, in 1955, in Montgomery, Rosa Parks was arrested for sitting in a section reserved for whites on a bus in Montgomery, Alabama. The same year, a young man named Emmett Till, a teenager that left Chicago, went down to Mississippi, whistled at a white woman. He was lynched. So America hadn't changed in significant ways. A decade later, in 1963, Dr. King came here, gave the incredible speech in the March on Washington. We only want to remember his first half of his speech, where he says, "I have a dream." But if you read his entire speech, he says there is a nightmare. It's not a dream today, it's a nightmare. He says, "I'd like my son to be judged by the content of his character, not the color of his skin." But the reality, in 1963, his son was still judged by the color of his skin. He talked about police brutality. He talked about the government writing a bad check for African Americans with insufficient funds. He talked about a Negro in Mississippi could not vote, and Negroes in New York didn't have anyone to vote for. So he came to complain about what was happening in America in the 1963s. So even though we'd made incredible progress, there still was resistance to the idea of changing our nation. And the all deliberate speed carries from 54. In many respects, it still is current in some aspects of our slow progress toward true integration and true opportunity.
Where'd you get the idea to write this book?
The idea came from a number of sources. First, I wanted folks to know that those of us who have made it shouldn't try to suggest that we've made it on our own. That I knew that there were giants on whose shoulders I stand. And I knew that I could be at the highest possible pinnacle at Harvard Law School. I could go to a private institution like Stanford University. I can serve on Stanford's Board of Trustees. I could have all this prominence, but indeed, I knew that I only made it because Thurgood Marshall and Robert Carter and Constance Baker Motley and Oliver Hill and Jack Greenberg and Bill Coleman and all the others opened up the doors. That's why. Number one, to show that none of us would have made it without that change. The second point is that as we celebrate the 50th anniversary, May 17th, 2004, we have to recognize that a lot of work needs to be done, because today in the 21st century, many of the schools that were challenged for segregation in the 1950s are more integrated now, and more segregated now than they were 50 years ago. So we have not achieved the goal that Marshall or Charles Hamilton Houston or any of the other lawyers had in mind. A second reason I wrote the book was that it's very interesting to see the change in the court from Marshall's time when he was a lawyer arguing cases and winning 29 out of 32 cases, or Robert Carter winning 21 out of 22 Supreme Court cases. Those were extraordinary accomplishments. That I wanted to show that this dream team, we've never had a group of African-American lawyers as successful or as committed to public interest as we had in the 30s, 40s, and 50s. And they've set a high watermark, and I'm challenging all of us who come after them to say we too must take on the awesome challenge of trying to promote equality in our country, and that we have a high standard to meet made by these lawyers. And the final reason for the book was to let young people know, particularly young African Americans, but all young people, to know that everyone can make a difference. I come from a very humble background. We grew up in poverty. We were on public welfare. My parents were seasonal workers. I worked in the fields when I was a kid, picking peaches and almonds and picking cotton. All that was part of my life in California in the 1950s and early 60s. And where you start has no reflection on where you will end. And I wanted to say that they were proud people. My grandparents, who grew up in Arkansas, my parents from Mississippi, from Arkansas and Alabama, they came from humble surroundings, but they were proud and focused on education, and made sure that even though they didn't succeed, my father finished only the 4th grade, my mother only went to the 10th grade. Education was always talked about in our home. They wanted to make sure that if they could not make it in segregated South in the 1930s and 40s, that their children, once we were born in the 50s and 60s, would have a better opportunity. And indeed, that's why, to salute those parents who made the ultimate sacrifice for their children to have opportunities in the 20th century.
After you graduated from Harvard Law School, came to Washington, became a public defender, and were about to be sworn in as someone who could argue before the Supreme Court at the Supreme Court bar, you invited your father to come. And your father hadn't been at your Stanford graduation or your Harvard graduation.
Right.
What happened?
It never was clear to me what was going on. My father was a very proud man, but he also was very, I think, embarrassed by his lack of success. I'm graduating from Stanford with honors. My wife is graduating from Stanford. And my father, who had planned to come, didn't show up. And I'm sure his feeling was, what can I say?
This is your father and mother?
Exactly. 1982. After my sister had been murdered. His point was that he's just a poor working class guy, and he couldn't say he went to school anywhere. He couldn't say he'd done anything of accomplishment, so he was very embarrassed by that. And the same thing at law school. Now I'm not just a college graduate, but I'm a lawyer now at graduating from Harvard, and it just was too much for him to take, and I was very disappointed. And so I worked with my cousin, Zamora Ogletree Eggleston, to try to get her father, who had been separated from my father since they were young. They were both men in their 70s then. They had left Alabama both, and they had not been together in 40 years. And so she was able to persuade her father to come from Buffalo, New York, here to Washington, where I was a public defender. And I talked to my mother and father to come from California to come to my swearing in. I thought it would be important to be in the Supreme Court. Thurgood Marshall was there. And again, what day was it? May 31st, 1983, which again was the anniversary of the all-deliberate speed, May 31st, 1955. So 28 years after that decision, I'm in the Supreme Court being sworn in. And the night before, my father called me and said, "Junior, I can't come." And I said, "Oh my God, I remembered college. I remembered law school. What would he say now?" I was not going to go for it. I bought him a suit, had some nice shoes. He was all traveled, ready to go. The tickets were there. Her mother was there, ready to go. I said, "Can't come." He said, "Why?" I said, "Why can't you come?" He says, "I don't have a hat." I said, "Excuse me?" He says, "I don't have a hat." He says, "I've got all these nice things, but I don't have a hat. I can't travel without a hat." I was furious. I didn't know what that meant. It made no sense to me that my father now had a 11th hour excuse. I talked to my mother, called our local department store in Merced. They were able to take the information over the phone, and she went down with him, and he got a hat, and he flew out here. And but it was amazing. He would not have come without the hat. But that hat was a metaphor that I have a lot of pride, but I'm not quite as proud as I could be, son. And if I'm going to be there on your day, I need to look right. He was going to be there to see this colored lawyer, Thurgood Marshall. And so it was a major event for him. And I never understood at that moment, but then something else occurred, Brian, that really struck me. I noticed when I started looking back, Dr. King often wore a hat. Thurgood Marshall often wore a hat. It was a sign of power, a sign of respect, a sign of courage that black men wore these hats. What I didn't know, I went back and looked at my college photos. Almost every photo I was in, And everything that I was doing, I had a hat. I didn't even know I liked hats, but I had somehow mysteriously adopted this philosophy of wearing a hat. And so the book actually has a picture of my father and his brother coming to the Supreme Court in their brand new hats with their brand new suits, and they could not have been two prouder black men